Welcome to this video. Today's topic deals with the situation where a parent requires a High Court order for the Department of Home Affairs to dispense with the requirement that the other party should consent to the minor child's application for a passport. This scenario may apply where a parent requires to take the minor child out of the country for whatever reason and urgently, but the parent who would remain behind has a problem with that, or the parent remaining behind has an issue with the minor child having a passport. Therefore, the parent leaving the country with a minor child urgently requires a passport but cannot do so because the parent remaining behind does not want to consent thereto. As the law stands at present, both guardians have to consent for the application for a minor child to have a passport. However, constitutionally, a child has a right to a passport. This application will be lodged in the Western Cape High Court, and the applicant being the mother, Kate Wellington, and the father, James Wellington. It is intended for the application to be heard urgently on the 23rd of March 2026 at 10 a.m. The first clause of your notice of motion, the document that you or your lawyer will draft, deals with condoning non-compliance with the rules of court. In order for a matter to be heard in court, there are certain rules and processes that must be followed, and with that, there are certain timelines that needs to be followed. In this specific example, there is no time for that, and therefore you are asking the court to disregard the rules for this specific urgent application. The first part of your relief is for an order that the respondent is directed to take all necessary steps to complete and sign all necessary documents with the Department of Home Affairs for the following minor children. And in this example, they are Tom Wellington and Sandy Wellington. And furthermore, if or should the respondent fail to comply with clause 2 above, the respondent's consent is not required for the minor children's application for a South African passport. And lastly, regarding costs, you state the respondent is to pay the cost of this application only in the event he opposes it. Further down in the notice of motion, you provide details of the law firm and you provide a timeline. Should the father in this example decide to oppose this application, he should inform either Kate or her lawyer within 5 days, and at the same time, he is informed that by the 15th of March, a certain date, he has to file his answering affidavit, whereafter Kate will file her replying affidavit. Attached to this notice of motion, there would be the affidavit of Kate Wellington and confirmatory affidavits if it is applicable. This document is either signed by Kate or the law firm, her attorney or trust account advocate, and obviously sent to the registrar and most importantly to Mr. James Wellington, the father in this matter, whose consent is required for the passport application of the two minor children. Before I proceed and deal with the founding affidavit, A few points to note. Should Kate be successful in her urgent application, the court would then make an order similar to Clause 2 of this notice of motion, where the court would state that the respondent is directed to sign all necessary documentation with the Department of Home Affairs for these minor children. And Clause 3, importantly, should he not do so, and we hope he does, but should he not do so, that his consent is not required. Obviously, should he comply and sign all necessary documentation, he would be at the Department of Home Affairs, and there would be no need to show this order to the Department of Home Affairs. However, should the father decide to ignore the order, then in that specific case, Kate would show clause 3 of the order to the official of the Department of Home Affairs, where it says that the father's consent is not required. Now we move on to the founding affidavit of Kate Wellington. In short, Kate would introduce herself, who she is, what she does, where she resides, is she married or not, and then go further to the details of the respondent, the father in this specific scenario, James Wellington, who he is, where he resides, what type of work he does, is he married, does he have other children, whatever is relevant to these circumstances. Obviously, my children, in this case, Tom Wellington and Sam Wellington, you have to introduce them, who they are, and maybe provide some information later on regarding where they reside, etc. Jurisdiction, obviously the court will have jurisdiction if both parties and the minor children resides there. To provide the court with some information regarding this application, and you stipulate under oath. This application deals with the application for the minor children's passport at the Department of Home Affairs, where the respondent is to provide consent. And you unpack it a bit more. Actually, very important, you have to explain to the court why your application is urgent. If you cannot do that, or you are unsuccessful in persuading the court why your application is urgent and the court does not see it as being urgent, the court will strike the matter from the roll and you may be liable for the legal costs of the other side. Going further, we provide information regarding the reasons for the passport application. The reason could be that the child has been selected for an international event, let's say soccer, to play soccer overseas via the school, and the child requires a passport for that specific purposes. Relevant background, here you may deal with information regarding the mother and the father, you were married, your relationship, when you separated, when you divorced, any relevant circumstances that will assist the court in determining whether or not the child requires a passport and what the purposes they are for. You might want to provide details regarding Tom and Sandy, maybe about the soccer, the schooling, and so on, the constitutional rights, basic of the child, and so on. Each case, but the end of the day, you need to convince the court that you have a solid case. And then your final relief would be that you like an order in terms of the notice of motion provided early on. After you issue your urgent application with affidavit, those documents, apologies, will be served on the respondent. He will receive a copy of, or she, depending upon the respondent, and the respondent will have an opportunity to file his opposing papers as in the specific example. In this example, he has to file it by Tuesday, the 15th of March, after giving notice that he intends to oppose the application. In his opposing in his opposing affidavit, He would provide information as to why the minor children should not receive passports. One example could be that it's a bad idea for them to go overseas, and therefore they should not receive the passports. Or he's afraid that the mother will not come back with the minor children, whatever his reasons are. He has to provide that information to the court so that the court would have the mother's case and his case as well, or his defense or opposition, and the court can make a determination as to whether or not the minor children should receive the passports or not. And after he has done that, the mother would have an opportunity to reply to any new information, new averments, new data that the father has provided the mother or to the court. And the mother would have an opportunity to respond to that. Because this matter is urgent and it would have to be heard on the specific date of the 23rd of March, before that date, all these documentation should be before the court. And on the 23rd of March at 10 a.m., the mother's advocate or the mother in person, if she is representing herself, will argue the case, will try to bring an argument to the court why the court must provide the specific relief sought in the notice of motion, as you have seen over here, and the father would have a chance to respond to those arguments, and then finally, the mother can reply to those arguments. Once the court heard both sides, the court would make a decision as to whether or not to grant the relief sought. As mentioned early on, the mother first has to get past the issue of urgency, and sometimes the court deals with both matters in one, and sometimes the courts deal with urgency first before dealing with the merits of the matter. Having said that, we wish you all the best with the legal matter, and thank you for watching this video as always.